The prosecution rests their case in regards to Lori Vallow. Did they prove their case beyond a reasonable doubt? Brian Kohberger gets another attorney. An update on that Utah mom who is alleged to have drugged her husband with fentanyl. And then finally, our dumb criminal of the day. Let's talk about it. Good evening, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. Yes, we didn't do a live last night because of obligations. We're doing it tonight, and we didn't get to do a show today because, well, obligations. So we're doing it tonight. So you know the drill. Subscribe if you haven't, like if you do, leave me a message, and also hit that little bell so you receive notifications of when you go live or when we go live and put up new content. And remember, you can listen to us anytime on any of your favorite podcasting apps. Now, let's also remember the people that, well, help keep Crime Talk out there and viable. Go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to conduct as many background searches as you would like on anyone in the United States. That report is literally generated while you wait. And guess what? It's going to be sent to you, and you can do with it what you desire. But it's going to have information about, I don't know, somebody's criminal history. Are they one of those public registries? You know what I'm talking about. Are they married? Are they divorced? Find out if they're telling you the truth. Maybe somebody's coming into your life that's new. Maybe it's your kids' friends, and maybe their parents just don't give you that warm, fuzzy feeling. Go check them out. Remember, you can cancel at any time, whether it's one search or 100 searches. You can do it all. CrimeTalkSearch.com. You'll be happy that you did. All right, let's go ahead and open the record for May 10th, 2023. We're going to do the docket, and then we will talk about, well, you know, Lori Vallow, a little bit of that Letitia Stout case as well. Guilty there. So, as you may have heard, I'm sure you probably heard already, the prosecution rested their case, and then the defense rested Tuesday after nearly 5 weeks of testimony there in Boise, Idaho. Closing arguments are expected to begin Thursday, and the courts spent part of the time today going over jury instructions to get that finalized. Now, one thing I want to talk about is an amendment that the court allowed. 2 years later, the prosecution figures out, oops, we charged the wrong statute. Oops. And of course, the judge lets them do that. But, when you do indictments, you don't get to make Scrivener amendments. I don't know. We'll see. Anything goes there in Idaho. Anything goes with Judge Boyce, I guess, as long as the prosecution generally asks for it. So it is what it is. But we want to send our thoughts out to Larry Woodcock. Apparently yesterday he had to be treated by medical personnel. And Kay, his lovely wife, said that Larry had been overcome with emotions, causing him to basically feel sick. He was treated and basically went home and took care of himself. So we wish Larry well. He's been on the show before, as well as Kay. And, hopefully they get the justice that they're looking there for young JJ. Next on the docket, Brian Kohberger gets another attorney. Now, I'm going to profess to you here. Brian Kohberger is represented by the public defender's office, but he's also getting another attorney who's in private practice. I'm not exactly sure how that works. It doesn't usually work that way. Usually once the public defender represents somebody, their entire office represents somebody. They don't go hire private attorneys to do that work. Maybe somebody can educate me on why that is. I just don't know. Now, for background, obviously, Brian Kohberger, he's the former Washington University PhD student accused of murdering 4 undergraduate students at a neighboring university across the state line there in Idaho. Well, he has a new defense attorney, Elissa Massoth, Massoth. Massoth. She is a defense attorney who attended the same school as the 4 victims, and she's been certified as a death penalty attorney there in Idaho, and she filed a notice of appearance with the 2nd Judicial District Court the other day. Now, as most people know, Brian Kohberger faces 4 counts of first-degree murder and a charge of felony burglary in relation to the November 22 stabbing deaths of Kaylee Gonsalve, Madison Mogan, Zaina Kernoble, and Ethan Chapin in the rental house on the edge of the University of Idaho campus. Now, his new attorney claims on her website to be one of the top criminal defense lawyers in Idaho. She graduated from the College of Southern Idaho, Boise State University, and the University of Idaho. She earned her law degree back in 1997. She initially clerked for an Idaho District Court Judge, Joel Horton, as well as Michael McLaughlin, followed by employment with one of Idaho's biggest law firms, Moffitt, Thomas, Barrett, Rock, and Fields. And at Moffitt Thomas, she focused primarily on business and real estate practices. And then while at the city of Boise, she spent 5 years prosecuting, climbing the employment ranks to become a senior staff attorney, managing a large team, and became one of the most successful trial attorneys in the office. In addition to criminal defense, she does a little bit of local government work, boards, works on civil areas, real estate transactions, some business entity formation, and some estate planning. Kind of a general practitioner. In the meantime, she's got one of the biggest cases going on in the nation. We'll see how that works out. Like I said, if somebody can tell me how the court is appointing a private attorney when the public defender's there, usually is not how it works, but hey, they obviously are doing it, so there must be a rule for it. Next, we'll give you an update on that other kind of situation with the Mormon mother, the one accused of poisoning her husband with fentanyl-laced Moscow Mule. And she texted a drug dealer friend for the, quote, Michael Jackson stuff, end quote, which she paid roughly $900 for, according to the arrest warrant. Now, Corey Richens is accused of murdering her husband, Eric, last March. Police allege she gave him a Moscow Mule laced with a lethal dose of fentanyl after trying to make herself the sole beneficiary of his life insurance policies. It just never ends, does it, ladies and gentlemen? Sex, drugs, and alcohol. You bring them all together, you got criminal defense, you got criminal law, you got true crime. Here it is. Well, in the year since her husband's death, she, grieved, and she wrote a book, a children's bereavement book titled Are You With Me?, which she promoted on TV and was quite successful. Well, Eric, who came from a very prominent Mormon family in Camas, Utah, was so convinced his wife was trying to kill him that he told his friends, if anything happens to me, it's her. Now, according to the arrest warrant, Corey texted a friend asking for the Michael Jackson stuff in reference to the fentanyl. And Mr. Jackson was killed in 2009 by a cocktail of prescription drugs of OxyContin and Demerol. In her text to the drug dealer, Corey claimed the drugs were for a real estate investor who had a back injury. Initially, she asked for the hydrocodone, a prescription pain medication, which the dealer left for her in a house that she was flipping. Then she said the investor wanted something stronger. She asked for that Michael Jackson stuff, paid $900 for 30 pills, specifically asking for fentanyl. 3 days later, on Valentine's Day, she and her husband had a meal at home, after which Eric became very ill. Now, according to the arrest affidavit, he told friends he believed he'd been poisoned, but he survived. Well, kind of, but he's also ODing. And according to the arrest warrant, Corey returned to the dealer and bought another $900 worth of pills. She used them to allegedly murder her husband on March 4th. And shortly after 3 a.m., she called 911 to report her husband was unresponsive. Yes, and obviously now dead. You just can't make this stuff up. And how did they get that evidence? That's right, the phone, ladies and gentlemen, the phone. And then finally, our dumb criminal of the day. Authorities said that Monroe County Sheriff's Office deputy was arrested for DUI overnight as he was found asleep in his private vehicle. Now, according to the spokesperson, the deputy, Jonathan Michael Lane, was taken into custody after he was found asleep while off duty behind a wheel of a private vehicle parked at a key gas station around 2 a.m. and was placed and relieved without pay pending internal investigation. So obviously feel bad for police officers, like anybody that gets in trouble. I'm sure, obviously police officers have lots of issues that they have to deal with throughout the day. But when you become a police officer, like anybody in public life, you have to do it better and cleaner than everybody else. So, unfortunately, officer, you are our dumb criminal of the day. All right, there you have today's show. We just brought it to you live. All right, let's talk about a couple of things as we get rolling here. First, let's talk about Letitia Stout. If you haven't listened to or watched the entire sentencing after she was found guilty, well, we have it for you. You can go and watch that. Pretty powerful. Obviously, all the victims got up and testify. Dad, getting up there saying he lost his son, never would have left him there. He's going to, regret leaving his son with Letitia Stout forever. But I think the best part of it was the judge. He nailed it. He just nailed it. And you got to love a judge like that. He just kind of sits there, sits back, calls balls and strikes during the proceeding. And then when the appropriate time came, he made the, what's the word I'm looking for? He just laid it out for her. Said, you've shown no remorse whatsoever. You've tried to take advantage of having a mental health issue. And really what you're doing is hurting people that really have legitimate mental health issues. And he says, normally when he's seen cases like this, and he's seen many, many of them as a judge, when they find out that they've had this basically psychotic episode, that they have no memory of it. And then yet Letitia Stout did. And, what Letitia Stout didn't remember is that the true professionals, the ones that deal with this stuff on a daily basis, they can call BS, just like the jury did. And so, it's good for the judge. Now, she will go spend the rest of her life, plus, I think, 30 some odd years or something, life. She's never getting out of custody. And then she had the audacity, can you recommend a placement for me? Really? And don't get me wrong. They ask sometimes in federal court, but not in state court, because the judge has no power to say which facility someone should go to. That's completely up to the Department of Corrections. They only have 2 female facilities, one in Denver, one in Pueblo. And, I hope you get the worst one, Letitia Stout. She's just a manipulator. She tried to play the game. She's not even good at it. And the only relief that she got was the district attorney wanted her to get to the Department of Corrections as quickly as possible. So they dismissed the escape case that they had against her. And I thought that was good for the DA. And that usually happens. We've all had that happen before. If you do serious cases, okay, my client's got a number of cases, but life without parole, what are you going to do? Some DAs will be like, well, I'll plead guilty to the other case and I'll make it concurrent. Woo-hoo. Or they just dismiss. And sometimes it doesn't really matter because at that point, it is what it is. So there you go. Letitia Stout. It's done finally. Thank goodness that. All right, now let's get on to Lori Vallow. Okay. Hold on one second. Let's talk about Lori Vallow. I want to see if I can pull this up here, because at the end of the case, the prosecution yesterday for Lori Vallow wanted to make an amendment. And let me see if I can play this here for you, okay? Because I think it's very telling. Let me back it up here. Let me back this up here. I'm not very good at this stuff. I probably should have asked Frank to do this for me, but I was listening to it, and you're just like, are you serious? Are you serious, people? Let me just back this up. Let me back this up here. See, hold on here. We're struggling through this. Let's see. This is it. Okay, hold on. So, this is frustrating. It really is. The prosecution indicted back in May of 2020. And how many times have that indictment been read? How many times have bill of particulars been asked for by the defense? And it didn't happen, right? Denied. You have enough information. Okay, here we go. So they want to amend the indictment. You don't just amend the indictment.
No, this is the first time I've heard of that.
Okay, I wasn't aware of that either.
So
that would be, I think, properly a motion to be argued outside the presence of the jurors. Would you agree with that?
okay.
Yes, Your Honor.
So the prosecution, oops, we're going to amend the indictment. You don't amend an indictment like you amend a complaint and information. Judge, here's an amended indictment. You have to go back to the grand jury and do it.
Well, given the status of where we are, I think we need to get that issue taken care of and resolved before the jurors probably return would be the time to do it. Although I do want to have the defense an adequate opportunity to see what the proposed amendment would be. So if you have that information, why don't you discuss it with the defense, and then I'll come back on the record and we can have a motion if there is one as it relates to any altering or amendment of the state's indictment.
Okay.
That sounds good, Your Honor. Thank you.
We'll be in recess.
Okay. So then they take a they take a recess. Jury's gonna, go do they're gonna go do their thing, and they come back, and the DA is like, "Oh,
notice of what she was charged with.
okay."
She was charged with grand theft by deception. I would note that either way, the state we believe we've met the burden of either of those. However, the plain language of the indictment is clear that she was charged with theft by the conspiracy.
This is them realizing
murder and grand theft
at
by deception.
the close of their case,
Not only is it in the heading, it's in the language.
they charged the wrong
All right,
paragraph in the
Mr.
indictment.
Mr. Wood, which of those counts were you seeking to have amended in the information?
1, 3, and 7.
And I'm telling you,
All right. Going back to just Mr. Archibald as to I actually don't have any further questions as it would relate to count 5 and the request to change the overt acts language.
just change the overt acts. Don't worry about it. It's only the biggest part of the indictment.
Considered both Idaho Code 19-1420, which governs the amendment of an indictment, which is what we have in this case, an indictment returned by the grand jury. I've also reviewed Criminal Rule 7E, which also relates to amendment of an indictment. 7E states the court may permit amendment of a complaint, an information, or indictment at any time before the prosecution rests if no additional or different offense is charged and if substantial rights of the defendant are not prejudiced. 19-1420 says an indictment or information may be amended by the prosecuting attorney without leave of the court at any time before the defendant pleads or at any time thereafter in the discretion of the court where it can be done without prejudice to the substantial rights of the defendant. An information or indictment cannot be amended so as to change or to charge an offense other than that for which the defendant has been held to answer. There's a case, State versus Jeske, 164 Idaho 862, 2019 case that says the decision to permit an amendment is a matter within the discretion of the trial court. That cites to a case, State versus Severson, 147 Idaho 694. The court may allow an amendment of an information at any time before the prosecution rests, so long as doing so does not prejudice the defendant's substantial rights or charge the defendant with a different offense, citing to Criminal Rule 7 and Section 19-1420. In a case, State versus O'Neill, 118 Idaho 244. So there is discretion here for the court to consider that under the rule. At the outset, I will note clearly the concerns raised by the defense that it just, the timing's sort of unbelievable with the number of prosecutors that have worked this case for so long that it's not something that came up in the course of trial or testimony. It's just making a correction here on whatever day of the trial we're at. We've been in trial for a very long time, and we're getting towards the end of the trial. And this is the kind of motion that clearly the court doesn't like, having all of our jurors sitting around waiting for us to take these matters up that could have been done by motion at any point before now. So
the judge is not happy. This is incompetent.
To consider this right now at this stage of the proceedings, but the rule does make clear that it can be done up until the time the state rests. The state has not yet rested. So there are 4 proposals sought to amend and change the indictment. The count 5 overt act 10, where it would be amended from months plural to months singular. The court finds that is more in the nature of a clerical correction and would not in any way affect or prejudice the substantial rights of the defendant by changing that. So the court will permit that overt act.
Don't worry about it.
Count 5 to be amended to the singular term month, not the plural term months. As it relates to counts 1, 3, and 7, count 1 is charged in the indictment as conspiracy to commit first-degree murder and grand theft by deception, a felony. It then does list the code sites underneath. 182403-4A is what's specifically stated there. Looking at that, I guess a few things. There's multiple purposes of an indictment, but mainly to put the defendant on notice of what they're charged with, and also to advise and instruct the jury what the defendant's charged with. The code sites probably have no and should not have any significance to the jurors, as they'll be instructed on what the law is as it relates to the Idaho Code section, which in this case is 182403. So the difference is there's a 4A sub. The state wants to amend to a 2A. So the court has to consider whether that amendment would be a substantial rights of the defendant coming into play as being prejudiced at this stage of the proceedings if the court were to allow that. There's another statute, I think, that can come into the analysis, which is Idaho Code 191417, which talks about words of the statute. Words used in a statute to define a public offense need not be strictly pursued in the indictment, but other words conveying the same meaning may be used.
You know what this shows, ladies and gentlemen. I'll try to wait till the judge is done here because he's going to grant it. But
count 2 under 192403 2A is a theft. Under A it says by deception obtains or exerts control over property of the owner. 4A is not by deception. It's where someone takes property and, quote, intends to deprive the owner permanently of the use or benefit of the property. Because the language of the indictment, not the code site, does include the term deception in count 1, both in the caption of what count 1 is, what's already been read to the jurors in this case, and also in the charging language at the end of the first paragraph. It says to commit grand theft by deception. The court finds on that count that the proposed amendment would not, at this point, prejudice the substantial rights of the defendant.
It's only a completely different statute. The subparagraph that she's charged on for the last 2 years.
Is a theft by deception. So the court would find that the indictment may be amended under Rule 7E as well as 191420 as to count 1 because it contains that explicit language of theft by deception. For that same reason, a mirroring language in count 3, which also is charged as, quote, conspiracy to commit first-degree murder and grand theft by deception. And in the charging body of the language, it also states to commit grand theft by deception. The court would find that did provide adequate notice to the defense throughout the proceedings of the theory under which the theft was being pursued, although it didn't conform necessarily with the subsection of 2403. So the court will permit the amendment on that count.
Of course he will.
And then finally, as it relates to count 7, which is a count of grand theft felony, that is just charged generally as grand theft, and the court considered that. It's charged under 4A. It does contain in the body of it as well the word deceit, saying that between Madison and Fremont counties, by deceit and with the intent to deprive another of property. And the court would note that that deceit language or deception is not contained anywhere in the 2403-4 subsection, but is only contained in the subsection 2. So the court would find again under 1914-20 that the indictment and under criminal rule 7E is not going to prejudice the substantial rights of the defendant in this case.
Yeah.
The motion's been made before the state rested, and for those reasons, then I'll permit the amendment as it relates to paragraph 7 of the indictment also.
Okay.
So the state's instructed to submit a conforming new amended indictment for filing in the case, which must be received by the court, obviously, before the jurors go in for deliberations and before the final instructions are completed in the case. That'll be the ruling on the motion then. Any questions on my ruling, Mr. Wood?
No, thank you.
All right. Any questions from the defense?
No.
All right. Thanks, Counsel.
Okay. Seriously. What the hell is going on in Idaho? Okay. Don't get me wrong. I'm no fan of Lori Vallow, but I'm a criminal defense attorney. When you charge an indictment, and how many court appearances have they had in this case? We only know of a mere scintilla of court appearances that have been in the public where we've even been able to see something taking place, because most of it takes place in chambers, like something I've never seen anything like it before, where they do a trial, pre-trial in chambers. Never seen anything like it. Unbelievable to me. Here we are. The indictment comes down almost 2 years and a month to when it came down. I think it was May 20th. All right, almost 2 years, right? All these court appearances, they're going to go death. They're going to, originally want to go death with Lori Vallow, the ultimate punishment. You're going to get super due process, dot the I's, cross the T's, etc. Now, once again, something that I've never heard about other than in Idaho, if they make an amendment in a federal indictment, if they make an amendment to a state indictment that I've ever practiced in, when you want to make that change, you have to go back to the grand jury for a superseding indictment. Otherwise, you're stuck with what you have there. Now, we didn't play it, but, Mr. Archibald basically was like, Judge, we asked numerous times for clarifications on this. You said, bill of particulars, under what statute, what subsection are you going forward on? Because you say one thing and the indictment says, and everybody poo-pooed the defense. The judge, oh, it's clear. You don't need a bill of particulars. You can figure it out for yourself. Listen, this is the kind of stuff that literally wants to make my head explode. Okay? Because this is the kind of crap that takes place every day in courtrooms. Freaking incompetence on the part of the government, and then they get up there, oh, we made a change, Your Honor. I know we're 3-4 weeks into trial now. What are we, almost 5 weeks, I think? 5 weeks into trial when you start counting jury selection. And it just suddenly dawned on somebody, oh, I guess I should probably, I guess we're going to do jury instructions. We should probably see if we have it charged under the right subsection of the statute where the defense has jumped up and down. A judge with a backbone would have said, oh, not in my courtroom. I get what the rule says, but that defendant over there, that counsel has made strategic decisions based upon that you guys got it wrong, the wrong subsection, and now you guys want to fix it. That's freaking incompetence. Incompetence. Close enough for government work. No big deal. I mean, am I the only one that's outraged by this? It's just, like I said, that kind of crap just drives me nuts. And then you got a judge who, well, I'm very concerned. We've had so many court appearances and yada, yada, yada. But I'm going to help you out, Mr. Prosecutor. I know you're incompetent. You didn't do this. I know the defense just made their argument that, we've relied upon this. We're going to be prejudiced, but I'm going to find that you're not. Oh, shucks. Close enough for government work. I'll bail you out, you incompetent prosecutor. Are you kidding me? Come on. Unbelievable. And yes, to the subscriber that asked a question, is that a appellate issue? Oh, you're darn right. It's an appellate issue. Like just about everything in this case has been an appellate issue. Yes, it is an appellate issue. I would argue it up and down every day. I mean, I had a case, and it was horrible homicide. We're talking multiple murders, just horrible. And it was a cold case. So, it was 20 years ago. And the prosecutor realized at some point that they made a mistake as to the statute of limitations and the statute that was in place at the time. And I refer to the SOB rule. If your client's an SOB, they kind of, poo-poo it, so to speak. And so they did a superseding indictment because they went back to the grand jury and said, hey, we need to do this. But they came back with just one charge. One charge. I'm like, okay. Everything else has been dismissed because superseding indictment, the plain definition, supersede to replace, only has one charge. And the court was like, are you kidding me? Are you kidding me, Mr. Prosecutor? You idiot. But he allowed it. And of course, my guy, was convicted and, multiple murders and maybe some sexual assaults before the murder and what have you. So, it was kind of the SOB. So they kind of, it was an unpublished opinion, no harm, no foul, which means has no precedental value. Basically no one else can rely upon it, but it was like, the guy's a really bad guy and, that's it. So, but it still irks me to this day because follow the law, call balls and strikes, read the plain language of the statute, the rule. Don't twist it to get to the result that you want. That is intellectually dishonest. It allows, and when prosecutors are allowed to be bailed out by the court on something like this, oh, judge's amendment, I'm sorry, it's only a homicide case that we've indicted 2 years ago and we just figured it out. We put the wrong subsection of the statute, which is what puts them on notice. Say, well, sure, they put 2A and it's actually 4A. And in the indictment, it has the kind of here's the little facts. That's not the charge. That's just little facts. They don't have to put that in there. They put it in, oh, they did this, this, and this. The only thing that matters is the subsection that's actually charged. And they couldn't even get that right. Now, when I was out there in Idaho, remember we took CrimeTalk 1, we buzzed out there for the day. We got in. I got my Lori Vallow commemorative overflow ticket to get in. Keep it right here. And the talk among the people that were there were a little concerned that maybe the prosecution wasn't knocking it out of the park. That was 2 weeks ago. Now, I ask you this, and let's be straight up, okay? We'll give her the presumption of innocence through the end of trial, through the verdict, because she's entitled to that. But, and I probably think, she had something to do with the death of their children. I don't think she did it directly. I think Alex Cox did it. The question is, was she manipulating Alex Cox to do these horrible things to JJ and Ty Lee that amounted to a conspiracy, or was it simply Alex Cox was a lone ranger on his own, or did he only make a move, so to speak, at the words of Chad or Lori? I think the jury will probably convict her. I will give you that. Okay. I'm a realist. But it just drives me bonkers when this crap like this happens. And then on top of that, remember all the big secrecy around this case? This is another thing that just gets me fired up. All the secrecy around this case. And, what? Hold on one second here. Okay, sorry. That's what happens when people on it. It never ends. Job never ends. All the secrecy that Judge Boyce put around this case, all the orders must be done in secret to protect Lori Vallow, the privacy interests. If you've been listening to these tapes that we've been putting up every night for the court trial, tell me, is there anything in there that is so salacious, so upsetting to the public that Lori Vallow and Chad Daybell could not get a fair trial? Like, really? Unbelievable to me. Nothing. Frankly, there's been anything new. A couple of text messages where they're getting hot and racy with one another. Ooh, okay. That's the big privacy interest to everybody? Like, what universe are they living in out there? I don't get it. I don't know. It just flabbergasts me. I'm not sure what they're doing. I was always concerned about the prosecution from day one. I mean, I wish them well. I hope they do a good job, probably carry their burden. But then here they go, 2 years. And right before they rest their case, oh, by the way, Judge, we charged the wrong statute. I guess we'll have to wait and see, assuming there's a conviction, if the appellate courts think that that's a substantial change. Or they're going to say, well, Lori Vallow's an SOB, close enough for government work. The prosecutors work for the government. Us judges work for the government. We can't get it perfect all the time. Close enough, right? As my boss used to say in the military, just remember all that gear you're using and wearing came from the lowest bidder. Remember that, ladies and gentlemen. But that was a long time ago. That was a long time ago where people didn't go to make a career in the government. It just didn't happen. People went, they learned their skills, so to speak, in the legal community, and then they left because pay sucked, and that was it. So, we'll see. Clumsy Clairvoyance, thanks for the super chat here. Thank everybody. We don't beg for super chats, but it certainly does help me see your question as they go by. Scott, do you think Chad's trial will have cameras? I sure hope so, because I think it's quite clear that there is nothing so outrageous, so shocking to the conscience, that there's such privacy interest that needs to be protected in any way whatsoever, that all of these proceedings should not have been in public and televised. I get the court has discretion. Once again, Idaho, stupid statute. The judge has all say, no way to appeal it. It is ridiculous. Come into the modern era. And I love the people of Idaho, but man, I don't know what your legislature is doing out there when it comes to some of these rules. It's clearly make it easy for the prosecution, the government. And come on, guys in Idaho. I thought most of you guys hated the government out in Idaho. Why are you making it easy for them? Seriously, it's supposed to be difficult. It's the way the founding fathers set it up. It's supposed to be difficult to pass a law. It's supposed to be difficult to make the government prove their burden of beyond a reasonable doubt. So I just think that it's, I don't know. It just drives me nuts. And that's the kind of stuff as a defense attorney you deal with every day. Well, I know I'm disappointed the prosecution, after 2 years and probably 80 court appearances, didn't find this, but let me do the work for them and I'll let them do it. I'm Judge Boyce, Mr. Eeyore Judge. I'm just going to talk like Eeyore, and it's okay. The prosecution can do it. They had sufficient notice. The not important part clearly says that they meant deception. The statute subsection that really matters doesn't say that, but they're on sufficient notice. Like, how is that not prejudicial? I have literally laid in wait on cases because they charged the wrong date. They charged the wrong statute. And then you get up and make your motion for judgment of acquittal, and the courts lets them amend it. I've even had a judge once where they had it all wrong. And I said, Judge, I make my motion for judgment of acquittal. They charged the wrong statute. There's been no evidence presented as it relates to this element that they have charged. Motion for judgment of acquittal should have been granted. The prosecutor, who's now a judge, whined, well, Judge, I'm going to look really bad in front of my boss if I lose a motion for judgment of acquittal. Let's take a break since it's the end of the evening and let me see what I can do. And of course, the following morning, what did the judge do? Allowed the prosecution to reopen their case after they had already rested. That doesn't sound fair, does it? Happens all the time. And so when I get upset with crap like this, it's because it's been, in my experience, 28 years of that crap. And it's like, those are the rules. This is what the rules are you play by. And then every one of those little statutes has some, well, if the prosecution can do it, because we know they're incompetent, we'll let them make their changes. Why do you think they put that in there? Because prosecutors have got burned. And like I said, I don't know what the hell's going on in Idaho. Just make an amendment to a particular change in a subsection. How is that not a material change 5 weeks into trial? Unbelievable. Unbelievable. Exotic Nebula, thanks for the super chat. What do you think Chad's defense will argue now that they've seen Lori's trial? Same thing I thought they would always argue. Alex Cox did it. He's a renegade. Sure, we had some crazy beliefs, but it's not against the law to have crazy beliefs. You know, we've all probably had a few text messages where you wished ill things upon, maybe the mother-in-law, the in-laws, the outlaws are coming to town. If my kid doesn't stop doing it, they're going to wish they were dead, right? I mean, could you imagine some of the texts that people have written over the years about family and friends? They're going to say, Alex Cox did it. Chad's going to have some problems with with Tammy for sure. And it just looks bad. I mean, come on, this guy, let's face it. He's a middle-aged white guy, right? Kids are grown. He's sitting there with his wife thinking, why do we like each other? Why do we like each other anymore? We've been married for 20 something years, whatever they've been married, right? And all of a sudden, this woman, who's not unattractive. I think we saw the video today of her being served a subpoena, sitting in the bikini in Hawaii. And there's Chad, a little overweight, little pooch belly, got the man boobs. And he's got Lori Vallow, who's, rocking the bikini. He's like, I'm all in, baby. I'm all in. Did he do it? Did he conspire to kill the kids? I mean, it would kind of seem like there's some talk. It would be a lot easier if the kids weren't around, just like when people have an affair, like, well, it'd be a lot easier if we didn't have to deal with the husband and, oh, you got the kids this weekend kind of thing. Does that amount to murder? There's no text messages that I've seen or heard any testimony on that says, go kill the kids. Kill the kids. There's nothing there, but, certainly it's circumstantial evidence. But in the eyes of the law, circumstantial evidence is given the same weight under the law. And, it's up to the jury to decide to give it whatever weight they truly believe. Now, you have to remember, you're going to have jurors here that have either A, not heard about the case or heard a little bit about it, but like, okay, whatever. And is it going to be enough to say proof beyond a reasonable doubt? Now, as an attorney, I look at some of this stuff and think, yeah, they probably proved enough, probably the conspiracy as it relates to the kids. Tammy, I mean, they didn't provide a whole lot of definitive answers. I mean, it'd be one thing if they said, hey, Alex Cox did it, but there was a conspiracy, and this is the smoking gun. And they never had it. Like I said, I think she's going to be convicted. But it wasn't, in my humble opinion, the most overwhelming case. I think if she had some attorneys a little more aggressive, and frankly, you didn't have to have access to all the discovery and you could have been a little more aggressive. I mean, Mr. Archibald and the other guy seem very nice. Very nice. Who doesn't like nice people? I try to be nice when I go to court. I try to be nice to everybody. But sometimes you have to not be so nice. And you have to try to do it without coming across like a jerk. Just saying. So I thought Lori Vallow's attorneys came across either A, too nice, or B, when they tried to get a little aggressive, they came across as a jerk. I usually think, trying to demonstrate absurdity with absurdity is the best course of action in court. So what you're saying is this email where they say, oh, the kids are, bad and evil today, and, they're going to be taken care of or something to that effect. What you're saying is that is the death nail for these children. Is that what you're saying, Mr. Investigator? Because that's not what it says, right? And just kind of go with him. Like, where does it say go kill JJ, go kill Ty Lee? Well, it doesn't. Okay, well, where in all of these text messages, these 1,400, what was it? I think in the iCloud account, I think they had 1,400 texts were relevant, but like 5,000 email. I mean, bunch of stuff, right? Just say, go through and say, where is the email, the text message of all the phones that you searched that said, kill the kids? Now, Lori Vallow, her biggest problem is the rest of the world is searching for her children, and she's rocking the bikini in Hawaii. That's just not normal behavior unless your kids aren't alive. I don't need to know where they are. I know exactly where they are. I need to go look for them. Right? It's not like that classic joke, when the attorney's up there giving his closing statement. In just a second, the victim in this case is going to show up and walk through those doors. Everybody looked. The guy gets convicted, and the attorney talks to the jury and say, why did you, everybody looked. Why'd you convict my guy? And they said, because your client didn't turn around and look because he knew they weren't coming in. Right. So she knew that, what's the word I'm looking for? Yeah. I see some stuff here. Storm. Yeah. That's apparently what they named Chad's, penis was, Storm. Yeah. I mean, these guys were like acting like a bunch of high school kids. I don't know. You must think the world is nothing but NPCS. I don't know what that means. NPCS. I'm not sure. All right. Here's a good question. Enough circumstantial evidence if I was a juror. I mean, circumstantial evidence, like I said, it's viewed, the jury will receive an instruction that will say circumstantial evidence is given the same, is admitted, it's not less reliable just because it's circumstantial evidence. But let me give you an example of that. Obviously, the classic example of direct evidence is if I go to the window and I see rain coming down, that is direct evidence that I observed at approximately 6:56 on May 10th, 2023. It was raining outside. I saw it with my own eyes. Direct evidence. I could testify to that fact. But let's say I wake up on the morning of May 11th and I look outside and it's not raining, but everything is wet. What does that mean? Well, circumstantial evidence would be that it rained. I didn't see it, but it seems like that's the way. Now, there could have been a lot of possibilities. Maybe the whole area is not wet. Maybe my neighbor's sprinkler did something, right? But circumstantial evidence gets a little less reliable when you're saying, well, I went outside and it rained or it snowed. I didn't see it snow, but there's snow there, so it must have snowed. That's circumstantial evidence. But when they say you got to go from this point to this point to this point and connect so many dots that you finally get there with all the circumstantial evidence, it gets a little weaker. Lori's hair on the duct tape. I would think, and hopefully the defense is going to argue this, not hopefully, but I'm sure they will. Okay, so let me get this straight. They found Lori's hair on a piece of duct tape on JJ, who was found in his pajamas. It's reasonable to conclude that somebody, i.e. JJ, at some point had contact with Lori Vallow. And there was a hair. Think about it. You ever had dog hair or your spouse, hair gets on you or whatever? I think you can explain away that. But I would think that somebody would have tried to bring that fact up during the trial. But they really didn't, right? I mean, if I was found, deceased, stuffed in the trunk of my car, taped up, and they found, a hair from the lovely Miss Kristen in my car and the duct, okay. It just means that they had contact with them at some point and that the hair was there. I mean, if it was a big clump of hair, like I'd pulled it out, that'd be a little more persuasive to me. But let's see. Let's see what's this question. If I was duct tape from my house was wrapped around my body, I'd be in jail for life. I have hair everywhere. Yeah, I mean, people, sometimes when it comes to physical evidence, you got okay, like I get it. Even with the the pic that they had that had DNA on it. Okay. Whose else DNA did you in your quest for that? It's not always good on DNA for wood. Assuming it has an accent. Okay, whose DNA was on the handle? I mean, I just thought there would have been more questions for the defense. I mean, I was just like, I listened to that stuff. I'm just beating my head. It's like, guys, I'm not even there, and I could think of at least 20 questions to go into. But they were just being nice, guys. And nice is okay, but every now and then you got to get a little rough. And say, sir, you can't say how that hair got there, can you? Well, no, sir, I can't. All you can say is that you found it there. You can't say if he had hugged his mom and that hair was there, or it was, she was combing her hair and it was on the sofa, which then got clumped to, his pajamas. No, I can't say how it got there, sir. All I know is that it was just there. I was asked to test it, and these were the results. I have no idea how it got there, under what circumstances, when, etc. Simple, stuff. And, you just don't, you got to do it. Let's see here. I'm looking at some of the comments. Outer tape, not inside the tape. Somebody said here there's something else, but it goes by so fast. Because it was on the outer tape, not the inside of the tape. I still would say the same argument. So what? Let's say she's found guilty of, the desecration of corpse. Remember all that stuff they were originally charged with? It's not even charged. I think it's tampering with evidence or something to that effect here. Doesn't prove, and I'm just being devil's advocate here, but it doesn't prove that she killed the kids, right? I mean, that's why they charged the conspiracy. So, we'll just have to wait and see, and who's going to want to talk to the jurors. It's going to be Mr. Pryor, Chad Daybell's attorney. If he can talk to the jurors, go talk to him. What's the significance? What did you think about this? I mean, the prosecution, yes, I hope they probably figure out they're going to amend the indictment. But I'd be curious to see if they go back and do a superseding indictment for old Chad. I think it's going to be an issue. There's going to be so many issues on appeal, just from a legal aspect of what took place, assuming the attorneys preserve the issues on the whole private, we are not China. We are not Russia, where things are done in back rooms. Court proceedings are in the open. I don't care if it is a small child testifying. It has to be done in open court. It has to be done in open court. And I've never seen anything like it. Apparently, whatever you want to do in Idaho, it works. I don't know. I've never seen any rules like it before. But it is what it is. I'm just flabbergasted by the incompetence. And I said, these seem like a nice guy. So probably get a conviction. The biggest fact is she's not looking for her kids, right? Think about it. If it was your kids missing and you didn't know where they were, you would be leaving no stone unturned. Not, nothing to worry about. I'm sure they're fine. I'm just going to go to Hawaii and get married without my kids. I think that is the most damning piece of evidence. The defense is going to say, you heard the detective say she was a good mom, the special agent. Remember that? It's which was the agent was kind of stumbled. He's like, well, she appeared to be a good mom, except of course, all this stuff, allegedly killing your two kids. That's not such a good thing, right? That's not a good mom. Okay. A good mom does not let her brother kill her kids. And even if she didn't do it and he knew he did it, you don't go along with it at that point and just say, oh, gee, I hope they don't find him. I mean, it's weird. It's weird. What kind of an idiot? You're going to, even if you believe all of their light darkness stuff and the levels and, their rating system, I'm going to make a rating system on a scale of 1 to 10. Chad Daybell, Lori Vallow, and Alex Cox, he's dead. But my rating system is 10 as a dumb criminal. No disrespect. I'm not trying to give anybody ideas, but you have a couple of missing kids. You got all this nonsense about you being the savior and the world's coming to an end and blah, 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 blah. And you drive like 10 miles north of town and you have vast forests out there, right? Just like in the South, they have all those swamps where people disappear to and all that good stuff. Looking in Utah, the lake, was it Lake Mead? I think is lowering there in Las Vegas, and they're finding all these cans full of bodies and things like that. But why would you bury the bodies at your residence, for God's sakes? I mean, did they think, well, they're going to watch us drive out of town? Well, not if they didn't take your phone. They didn't know you did anything wrong. I mean, like I said, these guys are idiots. They deserve their felony stupid. I mean, and I'm not trying to make, light of it, but you just like, are you kidding me? Like I said, they had some nice attorneys. They seem very nice. I just a little surprised by the lack of effort. That's probably one of the worst opening statements I think I've ever heard in a double homicide case. You would have been better off not saying a word or simply saying, ladies and gentlemen, my client is not guilty. All it takes is an allegation to get through those doors over there. Now the government has to be held to their burden of proof and prove the case beyond a reasonable doubt. The highest form of proof known in the law. And when you hear the evidence that the government brings you or fails to bring you in this case, you're going to find that it is not sufficient to sustain a guilty verdict. And you'll have one simple decision to make, and that's to go back there in that jury room and check the box for not guilty to all counts. Thank you very much. I did that off the cuff. Mr. Archibald had, year and a half to prepare for that? And he got up and said, well, most cases resolve. And, sometimes when they don't, that's where you come in. And you need to decide. And maybe that's his shtick. I just thought, this guy's done a bunch of homicide cases. You couldn't come up with something a little better than, aw, shucks, we're here. I don't know. Then we got the prosecutors. Don't worry. I'm sure they were going to criticize the heck out of CrimeTalk, as well they should, because it will make me better. And then you got the prosecutors. 2 years post-indictment. Oh, judge, we put the wrong statute in there. Oh, sorry. Sorry, judge. But, thank God we got that safety clause in there so that we can do it. So we can just make the amendment. Unbelievable to me. Idaho, you never cease to amaze me. You never cease to amaze me. What can you do? Lisa wants to know, super chat. Thank you, Lisa. How long do you think the defense will go in closing statements? Well, I don't know. I don't know how long they're going to get in closing statements. It varies from judges to judges. I don't know what Judge Boyce does, and I'm sorry, I don't know. Some judges will say, I'm going to give you, on a case that's gone this long, 4 hours, 5 hours, half a day, right? And everybody knows from, if you've listened to the tapes, everything has been PowerPoint, a summary of their slides. I can't believe the defense hasn't objected up until about 2 days ago and that the judge has allowed it. Here, let me put up a PowerPoint. No, how about you submit something into evidence, not just give me a summary of a PowerPoint. Make them work for it, for God's sakes. Your client's on trial for 3 murders. At least you could do is make the prosecution crawl over glass just a little bit to get the conviction, for God's sakes, not just give up. Jeez. Other judges will say, I did a trial, I don't know, a couple months ago, and he was kind of like, yeah, I don't give attorneys a limit on the time. If you'll know when you're done, the jury will let you know that you're done. But I'm not going to limit juries. And that's fine. It was a simple case. I think each side maybe took 30 minutes, 45 minutes at most. We'll see. Sometimes I've given 5 minutes, a couple hours. It just depends on the case. So I don't know. We'll find out. It's going to be worth listening to the audio. We'll get, as soon as we get the audio, we'll get it up. We try to do that. Super chat. JR, my next 50 years. Should Chad take a plea deal to get death off the table? Does Lori have any issues that would warrant an appeal? Taking the second question first. Yes, I think there's lots of issues. I think the whole issue regarding all this nonsense in chambers, I hope the defense objected to that. We don't do trials and pretrial in chambers. That's in this whole privacy interest. I still have not seen anything. There's nothing in that trial. Think about the Alec Murdaugh trial. Think about the Letitia Stout trial. All those motions, you were able to go in and watch them in the courtroom. I think we even put a couple of them up. Alec Murdaugh, same deal. He's accused of killing his wife, his son, and all the other bad things that he may have done. Or well, he admitted to it. And it all got out there, and he still got a fair trial. Letitia Stout, same thing. Killed accused and convicted of killing young Gannon Stout, 10. All in the public. Everybody knows what's going on. Fair trial. Jurors take their jobs seriously. Idaho, they have this privacy interest. It's going to protect their interest to a fair trial. Wouldn't it be ironic that in overprotecting a right to a fair trial, you actually violated the constitutional right to an open courtroom, right? A public trial. Yeah, so we'll see. Should Chad take a plea deal? I don't know. If he did it, he may want to consider it. If he didn't do it, he shouldn't plead guilty to something he didn't do. That's the general rule. We're not talking about, you get a speeding ticket and they say, we're going to plead you to a defective headlamp. And you're like, well, I really didn't have a defective headlamp. I'm a man of principle. I can't do that. Nope. You do it anyway. Okay, fine. I'll take the 2 points. It's, going to be a $30 fine. I don't lose any points on my ticket, whatever, right? Not a moving violation. My insurance isn't going to go up. You take it. But we're talking about a murder conviction. You don't plead guilty to something like that unless you actually did it. And you don't do it unless, if there's no offer on the table, then you don't you say, fine, I'll see you in trial and I'll make something happen. Tell your client, make no promises or guarantees. You're not entitled to an offer. Sorry, sucks being you. Either you're going to got something to work with or, it's going to be a long couple of weeks. It's going to be a long, drawn out guilty plea. That's just the way it is. If Lori is granted an appeal, will she get new lawyers or will she be with the same ones, the attorneys? And will the prosecutors be the same? It just depends. So normally what happens, she is court appointed. There's court appointed attorneys. I'm not going to say I know how it works in Idaho, but normally what takes place is a trial attorney does it. Then they turn it over to appellate counsel, whether it's the public defender's office appellate counsel, or she gets private appellate counsel to do the appeal. It would make sense if somebody on their team was an appellate person that they could take it and run from there because they know what the issues are. But I always think it's a good idea to have somebody else take a look at it. So you don't put on blinders and make a mistake and maybe don't see an issue, or you fall in love with an issue and it's not really an issue, or the appellate people are like, that's not an issue. What do you all, well, I'm outraged. It was a travesty of a mockery of a sham that this took place. And they're like, yeah, it's no big deal. Sorry, Scott. Prosecutors come and go. I know these are both the elected small towns. They come and go, they flip flop, etc. Who knows? They probably should have had the AG do it. I mean, I don't know. I think of the defense. I mean, I just sat there and I was literally like, just beating my head against the desk saying, object, ask some questions for God's sakes. I get you want to get the 404B stuff, all the 404B evidence of Charles Vallow being shot in Arizona. I object, 404B. Okay, once again, if the facts it's coming in, you've objected to it. It doesn't mean you can't embrace it, right? Like, okay, Charles Vallow, he's the one. Alex Cox shot Charles Vallow, right? Wasn't Lori Vallow. Nobody's saying she did it, right? She was calm. How do people grieve? How do you know? Doesn't mean you killed him just because you're not a nice person. Doesn't mean you killed anybody. So I don't know. I think there's plenty, it is what it is. I've tried to be respectful. I've tried to be nice. They're the ones trying the case. I can imagine. I know I've been there when, it's a high profile case and everybody's second guessing you. And so you got to do it. I get it. It is, I don't know. We'll see. Tomorrow's going to be the day. I wish the court would televise closing statements, but he's not. Only the verdict. So, and we got to watch the judge's YouTube channel, but we'll bring it to you live. Maybe we can even put a little clock from the time that the jury gets it. Start the countdown. How long have they been out? I don't know, Frank. Can we do that? Frank's not responding. I think he's thinking. Oh, he's trying to figure it out. It doesn't matter. We'll bring it to you live. We'll figure it out one way or the other. Yeah, Stephanie says she had no concern for her children. She wasn't reporting them missing or looking for them. I agree. That is the worst fact for the defense right there. We've talked about this. Had a judge say it. You're a mom. You got one job. That's to protect your cubs. That's what you do. And you failed. You failed because she thought she was going to get the life insurance policy. People do it. Look at that lady in Utah. Tried to get her husband's life insurance policy. Oops, he changed it. Why? Because he didn't get a warm, fuzzy feeling. That time that she, tried to poison him with fentanyl. Yep. There you go. Happens everywhere, which I think is funny that the guy was having a Moscow Mule and he's apparently some devout Mormon, but yet he's drinking. I thought they don't even drink sugar, for God's sakes. But he was drinking. So it just shows you the hypocrisy everywhere. Trust no one, ladies and gentlemen. Trust no one. Go to crimetalksearch.com and get that background subscription service. Check them. Do a background search on them. Be careful out there. It is a dangerous, dangerous world. Okay? Maybe your husband doesn't like you. Do you have a few bucks? Do you have an insurance policy? Maybe you want to give it to the kids. Just saying. Seems to be a lot of people trying to kill the spouse, trying to make the money the old-fashioned way, inherit it, or get it from life insurance. Scary, scary world, ladies and gentlemen. Be afraid. All right. So guess what we're going to do? We're going to take a quick break, and then we're going to jump over to our Patreon show for all our Patreons. If you'd like to continue the conversation, please come join us. If you haven't joined, I think there's a link down below where you can do that. It's nominal. But guess what? The lovely Miss Kristen got me a new Magic 8 Ball. As you know, the old one was given to me by a young associate that I had years ago. And frankly, it's lost some of the liquid in there. It doesn't work so good. So the lovely Miss Kristen got me a brand new Magic 8 Ball. So we will ask those questions. Maybe we'll ask the Magic 8 Ball if the prosecution's proven their case beyond a reasonable doubt, and see what the Magic 8 Ball tells us. I can hardly wait. And of course, our Patreon members, we also get the call-in number. That's right, the secret bat line number here to the Crime Talk cave, so to speak. And you can ask any question you want. We'll answer it. It doesn't even have to be about legal stuff. Just facts, questions of life. Crime Talk's here for you. Be afraid. Take care of yourself. Okay? Thanks for watching, and we'll see you next time on Crime Talk. And hopefully we'll see a few of you over at the Patreon page. Come join us.